My name is Annabelle Raw. I'm the health rights lawyer at the Southern Africa Litigation Centre, and I'm co-chairing today with Flora Sanam from ICW, and she runs their advocacy and communications work. So we've got an exciting topic today, and we're very grateful that you were willing to leave Elton John and Prince Harry to come and participate. Florence will introduce each of our speakers, and we've decided that it'll all speak in turn, and then we'll take questions and answers at the end. So please do note your questions so we can have a fruitful discussion at the end of the session. Florence.
Good morning, everyone. Thank you, Annabelle. I'd like to introduce our first speaker, Sally Cameron. Sally will be speaking to us about the new AIDS denialism, how criminal courts dismissal of modern science perpetuates HIV stigma. Sally has worked in the HIV policy and education for more than 2 decades, and she's a senior policy analyst at the HIV Justice Network. Immediately prior to that, she worked for the Australian Federation of AIDS Organization. Her expertise is in HIV criminalization, and this is internationally known. Welcome, Sally.
Okay, well, just sorting out how to get into the first slide. And there it is. Okay, so I don't know, I'm still a little emotional after the plenary this morning, but I will try and calm down and present in a clear and measured manner. But I don't know if you all saw the presentations by Alan and by Robert, but it was really fantastic, and even more fantastic was the reactions of people sitting around me in the room who, it appears many of them had encountered this issue for the first time. So I think it's a real breakthrough, the plenary, and I'm very, very happy to have been there. Okay, so just to start, I want to be clear that this morning I'm talking about HIV criminalization in terms of people not disclosing that they have HIV before sex, a possible or a perceived exposure, and transmission. So I want to acknowledge the many intersectionalities. We know what they are around sex work, around men having sex with men, issues of sexuality, gender, transgender. It's a long, people using drugs. I'm not meaning to be flippant about it, but that's not the focus here. The focus is really on the use of criminal law around people's HIV. So to frame it, we know that people living with HIV are used to having their bodies policed. So there are issues in relation to travel, applying for residence in a country, mandatory testing, including relating to employment, accessing healthcare, health insurance, life insurance, and the list goes on. But really the focus today is to make sure that you are aware of our most recent data, mapping HIV criminalisation laws and also cases. So this is the most recent map showing where HIV-specific laws exist in the world, including a couple of examples there of where laws are being recommended. It includes 100 jurisdictions in 73 countries, so it is widespread. I don't know, this is often seen as quite a small issue or an issue on the side, but I think particularly in a global context, we can see that it is happening all over the world. Our recent scoping spanned from October 2015 to June 2018, and it showed that 2 new HIV-specific laws were enacted and 2 more were proposed. As well as that, and most disappointingly, 9 countries applied their HIV-specific laws for the very first time. So the rhetoric about the laws being on the books but they're never used doesn't bear out in reality. You can never know when the law will be used for the first time, and you can never know who it will be used against. So people's kind of sense of comfort and complacency is a real danger. So obviously there are problems with HIV-specific laws. They are overtly stigmatizing. They often don't reflect current science. Issues of intention and risk can be irrelevant. For example, many countries have laws saying that people must disclose, regardless of whether they have a plan to use a condom, what their viral load is, whether the act carries any risk of transmission at all. Laws are often misnamed, so that words like intentional or deliberate are often in the name of the act. What that means is when it's reported in the media, that is repeated time and time again. When you dig down, there's absolutely no intention evident in what has occurred. And my bugbear, usually intent is attributed to the act where in fact there is none, because a person's intention to have sex is not the same as an intention to transmit HIV, and that is where these laws really miss the mark. HIV non-specific laws are used, so often it's things around assault, grievous bodily harm, in Canada sexual assault. Between October 2015, same period, and June 2018, 9 jurisdictions applied general criminal laws for the first time as well. So I think as police and prosecutors in different countries are becoming aware of this issue, they also become aware of the possibility of using their existing laws to prosecute people. And use of repealing HIV-specific laws is vital, but it's not enough alone, because what we see is often the consequences of the non-HIV-specific laws can be harsher. So they can involve longer sentences and they can involve sex offender registration. Okay, so this is our latest map of where HIV-related cases have been reported. In at least 115 jurisdictions in 76 countries, there have been prosecutions related to non-disclosure, possible exposure, or transmission. That's a lot of countries are coloured. The majority of reported cases in the study period were from the US, Belarus, Russia, Ukraine, Canada, and Zimbabwe. And then we went back and we looked at where prosecutions are highest per capita. And the two standout countries there are Belarus and the Czech Republic. But you can see there as well, there are many other hotspots. The red is where they are the largest proportion of cases, according to the number of people diagnosed with HIV in that country, moving down to the yellow. So this map's important because it suggests where we need to focus our advocacy efforts, where we need to build networks and really start discussion at community level. So what else does the data show? Well, the demographics don't reflect the epidemic, so no surprise, marginalised populations are overrepresented. The people who are already under scrutiny by the government, by the police, are far more likely to be sucked into this vortex of HIV criminalisation. And it's really clear in some instances where there have been mass arrests. For example, the situation in Taiwan where a group of men were at at a party, MSM, gay men, and the whole group were arrested and taken in. Something else is going on there. What the data doesn't show. So it doesn't show how these prosecutions perpetuate stigma, particularly through the media coverage. So they are, you really can't overstate how stigmatizing it is of the individual who finds their name and all their details splashed across the media, but also of all people living with HIV. And it affects the way that police perceive people with HIV. It affects the way police see members of other marginalised communities. And it affects the way the communities perceive themselves and the kind of discussions that do or don't occur within those communities. And the other thing that the data doesn't show is the large number of cases that are initiated by ex-partners. So it doesn't contextualise these cases in terms of the kind of things that happen when relationships break down, and not necessarily breaking down because a partner has learned that the person had HIV. Relationship breakdowns for whatever reason, which is an issue about why people end up trying to go to the police. Okay, so Many of you in this room have probably encountered this issue before, but what I wanted to say was, usually when I speak about this issue, it's to people involved in HIV, experts in science, clinicians, various areas, and generally because of that experience they say, yes, we don't really think that there should be prosecutions. It's we don't really like it, but we just want to make sure that there are laws there to prosecute those people who deliberately infect other people. That is our new challenge, to address that stereotype, that concept is useful for us. Because, this is the slide that I've used for a while, most cases involve a person who's having sex without disclosing their HIV status, and some involve spitting or biting. So many of those, there's only a possible or a perceived risk of exposure. In many cases, there is no transmission. But more importantly, there's often no or only an absolutely negligible risk of any transmission occurring. The people being prosecuted are not the people who are going out there with a plan to deliberately infect someone. Recent cases show that, this is just 2 examples, incarceration and sex offender registration for consensual sex with someone with a low viral load. And another one, the denial of an appeal against a 30-year sentence for consensual sex, someone who used a condom and also had a low viral load. So I don't want you to quote these figures, they're very interim. We are partway through a review of all the cases during our review period, that almost 3-year period, where we are trying to track, in fact, what is it exactly that people across the world are being prosecuted for. So this isn't cleaned, it's not the whole world, we've still got a little gap at the end, so please don't quote it. But of the 193 cases, you can see what people are prosecuted for, and you can see that without even thinking about condoms or viral load, a whole lot of those things don't involve a transmission risk. When we have a look further and at the cases involving sex where a condom used, a person's on treatment, or the case records information about low viral load and treatment's not mentioned, we have a large proportion of cases where there was little, not even little, negligible or no risk at all of transmission. Yet we know that more than half of the people in the study were jailed. And it's more than half because a whole lot of cases aren't resolved yet. So more people yet will be jailed from that list. And we know that people are held without bail and then they're found not guilty. From the whole scan that we've done so far of more than 200 cases during that almost 3-year period, maybe 2 to 3 involved a person having a plan to hurt somebody. We will look further, we will look at the court reports and the case studies, but that is vital for the people who are worried about the tiny number of people and that's over an almost 3-year period. So maybe once a year, somewhere in the world, someone has a plan to harm someone by transmitting HIV. That is our starting point. That needs to be put over there while we look at what is actually happening for everyone else. Okay, the expert consensus statement. Have you heard it mentioned? I keep hearing it mentioned. On the science of HIV in the context of criminal law. So a global panelist of leading scientists have developed a statement where they explain the risks of HIV transmission associated with different acts. It is aimed at expert witnesses, but it will also be helpful for police and other people in the criminal justice system. It is specifically written so it can be used in a courtroom to think about the risk if there is one instance of sex and then the various things around it. Unfortunately, it is embargoed until Wednesday at 3:15, but keep your eyes out. And it will be our mission, if we agree with all its contents, to try and push it into courtrooms around the world and stop prosecution of people where there is no scientific evidence that they've actually put anyone at risk. So, prosecutions. They reinforce a narrative of incredulity that a person didn't disclose their HIV status before sex, but in the context of this room, There is nothing unusual about that. If you talk to HIV clinicians, they know there's nothing unusual about that. No one's out there saying that no one don't disclose. That's not the platform that we have here. It's saying that human behaviour is what it is, and so what we want are supportive systems that encourage an environment where people feel safe to disclose, where people are actually able to disclose their status when and if it's relevant. Prosecution, subvert all our public health strategy, which is, really what this enormous, extremely expensive conference is built around. And they undermine the human rights of people living with HIV, particularly people who are from more marginalised or already criminalised environments. So in closing, I just want to say, science won't fix HIV criminalisations, but it will reduce prosecutions. That will be an enormous success if, in 3 or 4 years' time we have half or a third of the number of prosecutions. But it won't end it. So while we are thinking about getting science into the courtroom, we also have to make sure that those people who aren't on treatment are not further marginalised. People have an expectation that if you don't get treatment, that's your fault. But Chris Byra at Beyond Blame yesterday made a really good point. If someone's not on treatment, then the government needs to have a long, hard look at what they are doing to have not provided treatment or not provided a safe environment for people to be able to access treatment and to be confident the treatment will be effective and not harm them and to be able to adhere to them. Last point, you are the litmus test. You must go out there and get rid of that concept about the people who are out there deliberately transmitting, and to reassure people there are laws in place to deal with nutters who go out and want to hurt people. HIV criminalisation is not part of that dialogue. Thanks.
Thank you so much, Sally. Next we'll have Ayako Ochoa, a lawyer, researcher, and director of the California HIV and AIDS Policy Research Center at UCLA, Larkin School of Public Affairs, and she will be speaking to us about how people living with HIV translated quantitative research into community action and legislative transformation. Welcome.
Thank you. So 2 things. I'm the Associate Director of the California HIV/AIDS Policy Research Center, but I appreciate the upgrade. And 2, I've never had the chance to say that Charlize Theron stole my thunder, but that's exactly what's happened to me today. So poor me. Let's start there. So I'm Ayako Miyashita Ochoa. I am at UCLA. I just want you to know that the working title was really about how quantitative research spurred change, but it was only spurring change through community action. And the thing that really strikes me in this moment is that actually I'm not the person that was supposed to speak today. The person that was supposed to speak today was a colleague of mine, a mentee of mine, Hussein Turk, who could not make it. Hussein is someone that I've worked with since he started law school at UCLA, and he is a person living with HIV. And when he came on board with me to serve in a legal services collaborative I was directing, I urged him to step forward. And I urged him to be the voice and the face of this movement. I'm going to tell you about this movement because that's what it ended up being. But this is the story about California. So some of you who are in the plenary have heard about the story that California has recently changed its laws. And I am really... Thank you. I'm really, really glad to be able to share this space with you and to tell you California's story, because it's a story that's still being written. So who is this? Who am I? So I am an advocate. I'm a legal services attorney. That's at the very core of who I am. So for years, I served mostly low-income people living with HIV in San Francisco and Los Angeles. I then started working at the Williams Institute, and they're joined by Amira Hazenbush. Wave to Amira, everybody. Amira, wave. Sorry. Has to be done. Who's actually carried on the torch of our HIV criminalization research. How many of you have heard about HIV criminalization research out of the Williams Institute? Okay. So I would encourage you to take a look at it. And I'll demonstrate why in a moment. So power. Question of power. So what is this academic doing at the podium? Haven't we had enough of that? I feel that way about myself. I think it's that maybe perhaps my message is slightly different. And it's that as a lawyer, I was sort of trained to think that legislative success was the goal. And one of the things that I've learned through this process, through this movement, is that the struggle doesn't end there. Perhaps that wasn't even the struggle to begin with. So I posit you to think about that as we talk about this topic of HIV criminalization. So there's a really short timeline. So California, like in all things, I live in LA now, everything's fast. In 2014, there was the Grinnell Gathering, which was in Iowa, led by Sero Project, the first gathering bringing together on a national level people living with HIV and allies looking at HIV criminalization across the country. In 2015, our esteemed colleague, former executive director Brad Sears, person living with HIV, executive director of the Williams Institute, said, you know what, we're going to be the first. We in California are going to move model legislation through the chain, up the ladder, and we're going to pass a change in the law. Elimination maybe, modernization maybe, but we have to try something here in California. So we said, well, look, we need to figure out what we're talking about here. And so the first step, as of course a research institute, is we need to understand what is the data around these laws, right? What is happening in California? So we started researching, most of 2014, 2015. 2016 was a year of organizing. I'll talk about that in a little bit. Organizing is a very, very fundamental part of moving something, right? As most of you will know better than I do. 2017 was a year in advocating, working in Sacramento, in our capital. And then 2018 has been personally my year of reflection. So there were a lot of people that eventually came to work on this movement. We had a very strong partner in Equality California and Lambda Legal. A lot of the big names. Positive Women's Network was one of the folks working with this coalition, but I'll tell you how this coalition started. So we left the Grinnell Gathering in 2014, and we came home to begin a series of conference calls where there were 3, sometimes 4 people on the telephone, and I got to be one of them. Yes. At the time, there were no other statewide efforts happening. There was no entity with major lobbying capacity involved. As a research institute, we were not allowed to be that lobbying party, right? So that's how we started, all right? We had no comprehensive state-based data. So no state in the United States had yet been able to look at comprehensive data across the state, all right? In California, for certain, we had some cases that were a part of, if you did a basic legal research question and looked and queried cases involving HIV, criminal cases particularly, you found a few things. But there was no research telling us how the laws were implemented, who was most impacted, and what the criminal penalties were. So I'd be remiss to not share with you the data. Sorry, sidebar. But it's really important to know. I'm going to leave these here and run through them fairly quickly because I think they're going to be publicly available, and I'd love for you to have access to this information down the line if you choose to look into it. But essentially, it started out with a series of phone calls to the California Department of Justice where Ayako says, "Hi, I'm a researcher from UCLA, and I was wondering, do you know if there's any way I could get information on the following penal code sections and health and safety code sections?" You'd be surprised. I mean, sometimes we don't have any special skills other than being nice on the telephone. Amira makes fun of me sometimes. That's your best skill. But through that, right, and because we are affiliated with an academic institution at UCLA, we were able to obtain criminal offender record information. Okay, that's everything from arrest all the way to past prosecution and then post-conviction. So this is for anyone who may have had contact with the criminal justice system under some of the HIV-related criminalization statutes. Okay, so in California, this is before all the changes, so I'm not going to give you an update on where we landed exactly, but I will say the most important one, I think, is at the very top, which is Penal Code 647F. That is solicitation while HIV positive, and that is a felony. It was a felony, glad to report. But it was the one that you're going to see in a bit had the most impact. So this is somebody, a person that was convicted of 647F was somebody that had already been charged and prosecuted and convicted of prostitution, who then was mandatorily tested, right, by the court, who had an HIV positive test on their record, and then who got pulled in once again and charged with solicitation. Now, solicitation, as some of you may know, does it require sexual contact? No. So this is a felony for a circumstance in which there may have been no contact at all. All right. So looking at these laws, what we quickly realize is that the bulk of these incidents were related to what? Solicitation. All right. So 95% of all of those incidents impacted people that were engaged in sex work or were suspected of engaged in sex work. So that's the first thing. Second, when compared to people in California living with HIV by race and ethnicity, and then contacts with the criminal justice system, do you see it? Are we there yet? It's this disproportionality, right? Between the percentage of people living with HIV in California and then the percentage of people that were criminalized under the HIV criminalization statutes. So if it's not clear to you as of yet, the disproportionality seemed to indicate that people of color, and in the United States, often referred to Latinx populations and Black communities, were more disproportionately impacted. All right. Now, when it came to outcomes and what really happened in these cases, the thing that you would need to pay attention to is that green bar at the bottom. The green bar indicates anybody that was essentially not charged and released. And so who had the greatest proportion of being not charged and released? White men. All right. Every incident in which HIV charges were brought resulted in a conviction. Every incident in which HIV charges were brought resulted in conviction. That's 100%. 90% of those led to immediate confinement. Okay. So you're looking at confinement that's not short. If you look at the longest sentences, specifically under that solicitation while HIV positive charge, 25 years to life was the longest recorded. How many of you, is this new for you, have not seen these data? I would assume many of you. Okay. So please, please take a look. Amira's done an amazing job, not just with the first round of reports. There's been a number after that. It's really quite critical, the work that the Williams Institute is doing in this regard. They've now moved on to other states in the U.S., and I think that you'll find it really, really eye-opening. So what does it mean to be organizing? All right, so early conversations, that's Ayako calling all her friends. Hey, you need to really care about this situation. Coordinating meetings, let's meet, let's have lunch. Conference calls, I know you hate these calls, but we really need to start having them. LGBT lobbying capacity, sorry, in California, man, that's where we have power. So we're going to use that power, right? And then education and outreach events, which was basically Ayako and her friends going out and talking to community-based agencies and organizations and people. All right. So the early problems we faced, I know I'm going to start running out of time in just 2 seconds, but the early problems we faced were the problems that sort of, I think, plague a lot of us that are moving legislative change. I think that we have issues when it comes to inclusion. And if you look at the data, as you're looking at this list of folks that really need to be involved in a movement, you'll see that they are the folks that are most impacted. You've heard this before. So our movement, our work, also suffered in this way, in that we struggled. We struggled to include people from a broad range of communities. All right. We tried to do everything the right way. We got funding, which is great. We created shared principles. We found a champion. We did messaging research, right? What a funded operation can do is a lot. And then we just essentially put a few people that know how to politically maneuver in Sacramento in charge. And we said, okay, let's go. Garnered community support. Hundreds and hundreds of organizations and individuals signed on. And we had a legislative victory. So that felony, the one that I spent most of my time talking about today, is no longer on the books. It was repealed. We eliminated the most harmful law. We got to a place where we got people to focus on laws and their impact on stigma. You know, as a lawyer, sometimes you want to be able to point your finger at something concrete and say, that's what stigma is. And HIV criminalization is about the easiest thing to point your finger at and say that about. So I think that it was really satisfying, unbelievably satisfying to have achieved this. But the bigger question was, well, what else are we connected to? What else is our movement, right? We've achieved this change. We've achieved this important change. But what are we going to do with that, right? So it left me thinking, and I've been stewing ever since. Essentially, our governor went against his own Department of Public Health and signed legislation. It was fantastic. But the question has always been on the back of my mind, at what cost? Did we promote diversity without inclusion? Did we do everything we needed to do to train people and to increase their expertise? Who's better at conducting law and policy work now as a result of this change? That's the question that troubles me. Are we committed to a broader strategy to eliminate criminalization overall? I'm sure that you all know very well that in our country, in our state, in California, in Los Angeles, we were the worst offenders, actually. The majority of these incidents happened in Los Angeles County, where I live now. And the thing is that the criminalization, it's not just criminalization of HIV, it's criminalization of poverty, it's criminalization of people of color, it's criminalization at the intersection of all of these things. And so the question I'm left with is what have we done? What was the point? And where do we go from here? Thanks.
Thank you very much. Next, we have Richard Elliott from Canadian Legal Network, who's going to be speaking to us. So Richard is the director at the Canadian Legal Network and is speaking to us about ending unjust HIV criminalization in Canada through community advocacy based on science and rights. Thank you. Welcome.
Thank you. So I actually get to tell you another story about another country just north of where the former speaker comes from. And I actually thought of the alternative title of this talk was Sex, Science, and Stigma, A Tale in 3 Acts. And so I've structured it that way. But let me give you, first of all, the basic legal context in which we're operating, because it's actually different from the Californian context, and I think it's illustrative to see those two different examples. Unlike California, we don't have an HIV-specific law in our criminal law. We also have criminal law that is federal and federal only, that applies throughout the entire country, although because of reasons of history, it's largely administered by provincial attorneys general and their designated crown prosecutors, except for the 3 northern territories in Canada, which are not provinces. And that's relevant for reasons that will become clear. So because we have no HIV-specific law in the criminal code, the way that HIV criminalization has emerged as a phenomenon in Canada has been via prosecutors pursuing and courts interpreting the use of other general provisions in our criminal code to try to prosecute cases where they felt that criminal charges were warranted. And I've listed up here some of the offenses in the criminal code that have been used over the years to prosecute people for HIV transmission, exposure, or non-disclosure. And in particular, the offense of aggravated sexual assault, which is mentioned at the bottom, is the offense that has been used far and away most frequently. Since the first prosecution in 1989, we have now amassed more than 210 prosecutions that we're aware of, and it's a reasonably accurate tally, we think. So Act 1, the Supreme's way in. The first time that this issue came before our Supreme Court was in 1988, and this was after prosecutors had been throwing those various offenses that I just mentioned at people and seeing what sticks. And there had been inconsistent results, including using assault charges against people. There had been some cases in which there were acquittals, particularly where people had pleaded not guilty and had actually resisted the charge. Those cases, for the most part, where people were being sentenced for assault, were cases where people had actually pled guilty, perhaps ill-advisedly. So the Supremes weighed in and actually clarified what had really been a somewhat unclear situation about, well, how should the law be used, or could it be used to prosecute? And they said that not disclosing that you have HIV, or potentially also another sexually transmitted infection, amounts to a fraud. So they analogized from, because our sexual assault provision says that if you obtain consent to sex from someone through fraud, then that consent is not legally valid, and therefore it becomes a sexual assault by definition. But the court was also clear that there have to be some limits on when not disclosing to a sexual partner might attract some sort of criminal liability, and so they turned to the concept of harm or risk of harm, analogizing from commercial fraud jurisprudence. And so they concluded that when there is a significant risk of serious bodily harm, there is a duty to disclose to your sexual partner. If you don't, it's fraud, therefore their consent wasn't valid, therefore you've committed a sexual assault. That's the basic logic, the legal logic that follows. Furthermore, we have different levels of severity of sexual assault in Canadian law, and in their view, exposing someone to the risk of acquiring HIV endangers life, and therefore, according to the definition of aggravated sexual assault, which is the most serious form of sexual assault, you are guilty of that offense. And that offense carries a maximum penalty of life in prison. And if you're convicted, it's mandatory that you be designated as a sex offender. The issue of whether using condoms to reduce that risk of transmission might preclude you from being prosecuted was before the court in a theoretical sort of way, not based on the facts of the case that was before them, so they didn't definitively pronounce upon it. Although the majority said maybe, and we'll save that question for another day, and a couple of judges in a concurring judgment, but a minority judgment, said definitely only sex without a condom, unprotected sex as they spoke of it at the time, should attract criminal liability. And that's also relevant for when we come to Act 3. So that was a certain degree of clarity from the Supreme Court the first time that they pronounced on this. And so what happened in the years following was that most of the lower courts that were now following this semi-clarified legal framework accepted the suggestion that condoms should actually be treated as meaning that there was no significant risk of transmitting HIV, and therefore you weren't a criminal committing sexual assault for not disclosing that fact if you had used a condom, which was a position that we had argued before the court. However, that wasn't universally the approach taken by lower courts, and there were some decisions to the contrary. So the law did remain somewhat unsettled on this particular point, and so it was not surprising that it would eventually perhaps work its way back up for some further pronouncements, as we'll see in a moment. What happened in these years following was prosecutions increased substantially in the years following, which is perhaps not surprising because the Supreme Court had at that point clarified the legal pathway that prosecutors could follow successfully to obtain a conviction. We also succeeded, however, in doing the first judicial training in Canada on the issue of HIV and the criminal law. And we know that that judicial training had direct impact on one of the cases that I'm about to mention, although unfortunately not lasting, because two of the judges who sat on the appellate court in one of our provinces who heard a case about condoms and about viral load and what that should mean for liability or lack thereof for not disclosing, actually subsequently ruled, having participated in this training, in favor of the positions that we had articulated. That condoms should mean you're not a criminal, that having an undetectable viral load, as we formulated it at the time, should mean you're not criminal for not disclosing. They went for that position, but that's not the end of the story. In the meantime, the scientists, of course, have been doing their important work, and they were building more science, particularly on the question of viral load and what its relationship is to the possibility of transmission. And the thing to note here in particular is the HPTN 052 results that were first reported in 2011, because those were results that were before the court in Act 3. There were a number of successful court interventions by organizations, including the one I work for, at different levels of court. And as I mentioned a moment ago, we did actually succeed in getting some positive decisions limiting the scope of criminalization from provincial appellate courts. And of course, at the same time, it's been very important to support defense lawyers who are representing people living with HIV and make sure that they're knowledgeable about HIV, that they have access to the latest scientific evidence that could be useful to represent their clients, that they think critically about the use of the law in this area, which many of them might not automatically do, because this isn't the kind of case that walks through the door every day for criminal lawyers. And so if you're not particularly familiar with HIV, you have all of the same sort of assumptions and baggage about HIV and stigma as anybody else does who doesn't know much about it. It's easy to sort of let things slide or plead your clients guilty in cases where perhaps they shouldn't have been pleaded guilty. So that's very important. We also launched a campaign inspired by some of the success in the UK, specifically England and Wales to begin with, for prosecutorial guidelines that could de facto have an impact on reducing the number of instances in which prosecutors took cases forward to courts. And of course, for 25 plus years, there has been ongoing media advocacy to try to challenge assumptions that are still, unfortunately, quite prevalent out there, that basically the appropriate response to non-disclosure is to resort to the criminal justice system. So all of these things were happening in the years following the first pronouncement from our Supreme Court. But not surprisingly, with so many questions unresolved, with some of the science evolving, with the activism that was being done criticizing where the law was headed and what prosecutors were doing, eventually 2 cases from different provinces worked their way back up to the Supreme Court for their second take on the matter. And this is Act 3 in 2012. And this time, the Supreme Court revisited the question of when there ought to be a duty to disclose, and therefore, if you did not, you had committed a fraud, and therefore had committed sexual assault on your ostensibly consenting sexual partner. And they specifically said that in the case of the harm of HIV infection, as opposed to other sexually transmitted infections that might amount to a serious bodily harm, that they were going to interpret this threshold that they had articulated in Act 1 as meaning that there is a realistic possibility of transmission. So those words in red are now the controlling test in Canadian law for when there is a duty to disclose and when you're a criminal, equivalent in law to a rapist for not having disclosed to your sexual partner. Now, interestingly, the Supreme Court went on at some length about how we should not be trivializing the use of the criminal law, and in particular the law of sexual assault, which is the rubric that has been evolving, by criminalizing speculative or negligible risks. However, in my submission, that is exactly what they went on to do in that particular judgment. And they concluded, having looked at the data from HPTN 052 that had been released the year before in 2011, and some data about condoms that was published in 2002 in a Cochrane review about the effectiveness of condoms, that in the circumstance where someone had both used a condom and had a low viral load, not undetectable, but low, which they defined as meaning under 1,500 copies per milliliter, with reference to the HPTN 052 study, then in that circumstance, there would be no realistic possibility of transmission. And therefore, you could say there is no duty to disclose. So this is an approach that Edwin Bernard, he of the pithy quote, has described as the belt and suspenders approach. You must have both the belt and the suspenders. We had submitted that, in fact, either of those things should suffice to reduce the level, the risk of transmission to the level that it should no longer attract criminal liability. Unfortunately, that is not where the court went. So even though we had those couple of judges that I mentioned who participated in our training in one of the appellate courts below, actually both the appellate courts below, accepting this proposition, the Supremes had a different idea. And what's particularly surprising about this particular conclusion in Act 3 of the story is that in Act 1, if you'll recall, a majority of the judges who sat on the court had suggested that, well, maybe condoms on their own will be good enough, and a couple of them went further and said, yes, definitely condoms on their own should be enough. It's only unprotected sex that should attract criminal liability. Unfortunately, this was a unanimous decision in which they resiled from that position, and in fact it was written by our then Chief Justice, who was actually one of the two judges who actually would have gone further the first time around and said, we're not going to prosecute people who use condoms. And yet here she led the charge, writing for unanimous court, saying, nope, condoms aren't good enough on their own. So, what do we make of that? It's important to note that it's not necessarily the end of the story, even though you might think at the end of Act 3, that's it. In fact, there's more. So the question that remains is, do we need to always have both condom use and a low viral load in order to avoid prosecution? And the answer, although some of us in the first disappointed 24 to 48 hours after this terrible decision came out, might have thought, yes, we're sunk. In fact, upon further reflection, not necessarily. So the story may not be over, there may yet be a happy ending, and that's what we're still working toward, because who doesn't like a happy ending? So, what has happened since that decision is that there have actually been, not surprisingly, some contested interpretations of what this realistic possibility test means. Now, mostly they've involved different approaches by courts to understanding the significance of viral load for whether or not there should be criminal liability. And I'm happy to say that the story is now, at least for the time being, shifting in the right direction, and I think we're gonna lock it in and get to that happy ending. So in the immediate aftermath of this Supreme Court decision, we actually had an unfortunate Court of Appeal decision in one of our provinces, Ontario, which is the province that has actually accounted for more than half of the prosecutions to date in Canada. It's the largest province in the country. And they said, well, this is how we interpret the Supreme Court here. You must always use a condom. It didn't matter whether you had a viral load that was low or undetectable. The Supreme Court said you have to have the condom as well. End of story. And in fact, we began to see, not surprisingly in Ontario, we continued to see aggressive prosecutorial stance, including pursuing people even when they had a low or undetectable viral load. However, in more recent years, the story's gotten a little happier thanks to advocacy, and advocacy that combines science and human rights arguments and public health arguments. We have seen cases in which marshalling the science in the hands of defense lawyers has led to prosecutors withdrawing or reducing charges. And we've actually had a number of trial courts, now they're only trial courts, they're not the Supremes, but nonetheless, they've actually been critical of the Supreme Court's approach, saying you've cast the net too broadly here, and we think actually you need to go narrower. And so we now have 3 cases that have actually accepted that an undetectable viral load alone will suffice to mean that there is no realistic possibility of transmission, which, as I'm going to show in a moment, has increasingly been scientifically validated, and therefore you are not a criminal guilty of sexual assault if you don't disclose. The condom issue, however, ironically, given it's the very first HIV prevention intervention in the epidemic that has been drilled into people from the beginning, remains unresolved in law. So what's been happening in the science and how has it affected the evolution of the law, at least in our context? Going back to 2008, some people will know of the infamous Swiss statement that we, of course, were using very much as advocates in the courts to say, this is a good scientific basis on which to be restricting the scope of the criminal law. It was contentious at the time, and it remains contentious in some ways when people think that what you're talking about is public health messaging as opposed to what the criminal justice system should do in individual cases of criminal accusations. In the last decade, of course, the scientific case for limiting the scope of HIV criminalization has only gotten stronger, particularly with respect to the question of viral load. I note 2 particular statements here, and the reason I highlight them in red is because, unlike the other statements, these are ones that actually address the issue beyond simply viral load and the impact of antiretroviral treatment. And that was very deliberate because we didn't want to limit our arguments about restricting HIV criminalization just to those who could achieve an undetectable or a suppressed viral load. It's really important in our advocacy going forward that we harness the power of U equals U, of course, but that we not stop at U equals U. And that's why I'm highlighting that the condom issue remains unresolved for us and is actually a really sticky one. The global expert consensus statement that is coming out tomorrow that Sally has mentioned should, I hope, be useful in that regard, that it will push us beyond just the U equals U arguments. So what have we managed to achieve marshalling the science? I can't quite tell if you're holding up the please conclude sign. You are. All right. It was sort of a suggestion, not really a command. So I'm going to just wrap up here by letting you know what we've achieved in the last few months by marshalling the science, building community, and working with defense lawyers and policymakers. We have marshaled a national coalition, which ironically has very sort of similar an acronym to the Californians for HIV, criminalization, reform, what have you, that has now articulated a clear advocacy agenda supported by the HIV sector across Canada. We have worked very closely with the Federal Department of Justice to issue a groundbreaking report from them recommending various limits on criminalization, including generally not prosecuting people who use condoms, for example, not just the viral load question. And in the province that has accounted for most of the burden of prosecution to date, we finally succeeded after 8 years of a campaign in getting new guidance for prosecutors that says people will not be prosecuted if they have a suppressed viral load for at least 6 months. It is an important step. It is only part of what we need to achieve. We unfortunately have a very shoddy new prosecutorial guidance from another province, British Columbia, that doesn't even go as far as the half-assed approach of Ontario, and so we need to keep up the pressure there. My understanding is that there is work ongoing in the province of Quebec that may lead us to something in the months ahead. We'll have to wait and see whether the content is good enough to actually be an effective limit on the scope of HIV criminalization. But we absolutely need to get the condom defense reestablished. We were, in fact, working on that. We were headed in that direction, as I mentioned, until our Supremes in Take 2 pulled the rug out from under us. So we need to revisit that question. And then finally, we're going to need to pursue legislative reform. We cannot get out of the box of sexual assault being used to prosecute people for non-disclosure through just having proper guidance for prosecutors. We need to actually remove HIV non-disclosure from the rubric of sexual assault, and the way to achieve that is through legislative amendment to criminal code reform, and you can find more information on these websites. Thank you.
Thank you so much. Our final speaker, and I'm sorry I may not pronounce your second name well, is Andrea Cruci, who's a PhD, is a research scientist with the Gender and Sexual Health Initiative at the University of British Columbia. Andrea will be speaking to the marginalized women living with HIV at increased risk of viral load suppression failure, the implications for prosecutorial guidelines regarding criminalization of HIV non-disclosure in Canada and globally. Welcome, and apologize for...
Well, hello everyone, and I actually did an amazing job pronouncing my last name, so... I think my talk is going to follow quite nicely after Richard's kind of outline of what's been happening in Canada, and I'm also hoping that the work that I'm presenting today will help us push beyond a U equals U approach and really kind of problematize that piece as well. So I'm going to speak about some work that we've done in Vancouver, just looking at how these prosecutorial guidelines that have been proposed in Ontario, how they could impact marginalized women living with HIV. So before I start, I just also want to acknowledge that the work that I'm going to present today and the research that we're doing in Vancouver, Canada, happens on the unceded and traditional territory of the Musqueam, Squamish, and Tsleil-Waututh territories. I also want to acknowledge the cis and trans women living with HIV who have participated in our research and who have so generously shared very private information with us. And finally, I would like to acknowledge also the community co-authors of this study who have been instrumental in the conceptualization of this work and in a write-up of this paper. So yeah, I don't have to talk about the legal situation in Canada very much, but so like we just learned from Richard, there have been some positive developments regarding the criminalization of HIV non-disclosure in Canada over the past year or so, for sure. And this includes a report by the Federal Department of Justice that really calls for the limited application of the criminal law in HIV non-disclosure cases. On the same day as that report came out by the federal government in 2007 on World AIDS Day, the Attorney General of Ontario, a Canadian province, as Richard has said, with the highest number of HIV non-disclosure prosecutions, they announced prosecutorial guidelines that indicate that people who have a sustained low viral load for 6 months will no longer be prosecuted in Ontario. So in response to these developments, we thought that we would examine the factors that are associated with not having a sustained viral suppression for 6 months and thus not meeting this legal test to be exempt from criminal prosecution among cis and trans women living with HIV in Vancouver. While women living with HIV in Canada represent only about 10% of all people charged with HIV non-disclosure, previous research suggests that women living with HIV carry a disproportionate burden in disclosing their HIV status in Canada. There is a growing body of evidence that suggests that despite frequently being portrayed as a law that actually protects women, the criminalization of HIV non-disclosure has significant negative effects on women, including increased risk of violence, which can contribute to some women living with HIV stay in abusive relationships for longer or fear blackmail when a partner might use their HIV serostatus as a form of control or threaten criminal prosecution. Given these significant negative effects on women living with HIV, we thought to evaluate the potential impact of these prosecutorial guidelines. So this analysis draws from a longitudinal study termed the Shauna Project. This is all community-based research. So we follow a cohort of over 300 women living with HIV who access services or live in the Metro Vancouver area. Women living with HIV are included in all aspects of the study, and the focus is really on the social and policy and legal and geographic factors that shape women's sexual health and HIV care. All participants complete a baseline interview and semi-annual follow-up visits, which include an interviewer-administered questionnaire by trained community and peer researchers, as well as a clinical study visit with a research nurse that includes HIV monitoring and STI and HCV testing. So the Shauna Project is a partnership of over 20 HIV and community service organizations and is guided by 2 advisory boards, a community advisory board as well as a positive women's advisory board that meets every 2 to 3 months and with about 12 to 15 women living with HIV representatives, and they guide the research process and provide feedback on findings as well. So to better understand the factors associated with being virally suppressed, we drew on 7 years longitudinal data from the Shauna study. So this analysis includes 264 women living with HIV who are on antiretroviral therapy. The primary outcome was having a detectable viral load in the past 6 months over the 7-year follow-up. Participants' viral load was recorded as part of their blood work during the clinical study visit or through linkages to the provincial drug treatment program, which records all clinical and virologic data from patients receiving ART in British Columbia. We conducted bivariate and multivariate logistic regression using GEE to longitudinally assess the correlates of not having viral suppression. And apart from socio-demographic characteristics, all variables are updated and refer to the past 6 months. So a staggering 59% of out of the 264 women in this study would not meet the legal test of having sustained viral suppression for 6 months for at least once during the 6 months over the course of the study, and thus they would continue to be at risk of criminal prosecution due to their HIV status. So at baseline, of the participants who experienced viral suppression failure over the course of the study, 11 identified as trans, and 67% of participants were of Indigenous ancestry. Indigenous women were highly overrepresented in our study and are also highly overrepresented among women living with HIV in Canada due to the ongoing effects of colonialism and dispossession. The use of illicit substances in the last 6 months among this group of women was high at 84%. 23% reported had experienced gender-based violence in the previous 6 months. 26% were unstably housed, and 79% of participants who had not achieved viral suppression over the at least once over the course of the study were sex workers. Experiences of incarceration were very high among this group of women living with HIV and among the women who experienced viral suppression failure. So 73% had experienced incarceration over their lifetime, and 11% had experienced incarceration in the previous 6 months. So this really, again, and I think this is really important, highlights the overcriminalization of women living with HIV face due to various interlocking vulnerabilities such as poverty, substance use, sex work, and HIV. So in bivariate analysis, Indigenous ancestry, experience of gender-based violence, illicit substance use, sex work, homelessness, and incarceration were significantly associated with having a detectable viral load over the course of the study. And then in a final model, in multivariable analysis, recent homelessness, recent sex work, and recent incarceration remained predictors of increased odds of not having suppressed viral load. So our findings highlight that approaches exempting people from criminal liability for HIV non-disclosure, conditional on maintaining an undetectable viral load, continue to put a large proportion of women living with HIV in Canada at risk for criminal prosecution. Those at highest risk of prosecution are the most marginalized women living with HIV, including those who face housing instabilities, sex workers, and those who have been recently incarcerated. So further action to limit the criminalization of HIV non-disclosure is urgently needed, and advocates, researchers, and people living with HIV need to continue to strategize how to best move forward on this front. And I just also want to end with, law should really focus on the protection of rights of women living with HIV, promote equality, guarantee sexual and reproductive rights, and ensure access to essential services, and also really importantly, privacy, rather than to regulate HIV non-disclosure. I just want to acknowledge the study team without whom this wouldn't be possible, and lots of the co-investigators, as well as all our community partners. Thank you.
Thank you to all our speakers. We do have a fifth speaker listed who hasn't arrived, so we will proceed to questions and comments. Just before we start, I wanted to thank everyone. We started with Sally Cameron, who really illustrated for us the ways in which what's happening on the ground and what's happening in the actual prosecutions seems to be at odds with the justifications based on stigma and fear that have driven these laws. Sally also raised for us, started the discussion on the question about how we ensure that those who are not on treatment are not further marginalized through the approaches that we're taking in resisting HIV criminalization. And I think inferring to us questions that Chris Bayer raised around how we're imputing individual criminal liability for health systems failures. Ayako really drew on these themes and explained to us the way in which her research has revealed how the law really embeds stigma and misinformation in the legal process. And I think really helped us to understand the value of the deeply invested and collaborative work that achieved the results in California, but mostly the use of friendly phone skills. We were grateful to Richard thereafter, who walked us through sex, science, and stigma in Canada, and who showed us that sometimes the Supremes are best left singing, in illustrating that we need both belts and suspenders in Canada. And finally, Andrea really highlighted how those who are most marginalized in our communities are those at the highest risk of prosecution, revealing the startling number of 59% of women living with HIV in her study who were found not to meet the legal test for viral suppression and so remaining vulnerable to prosecution. So at this stage, I'd just like to thank the translator. So if you're hearing someone speaking in the background, that's someone translating in the back of the room. But in the meanwhile, if anyone has questions, please come forward to the mic. There are mics dotted around the room. So we're going to start with the gentleman at number 4.
Thank you. My name is Martin Owino, a Kenyan Member of Parliament. And I want to thank the presenters because I needed some of these legal opinions as we try to reform our legislation. It's tough for us because sometimes it's difficult to put a line between intention to have sex and intention to transmit HIV infection. We are looking for the wordings. We don't want to leave the prosecutors chances of interpreting the law in a way that discriminates even further. So I really want to have maybe wider experience. As a member of a health committee, we are tasked to do that because I saw even my country there, Kenya, displayed as one of them. But we have a chance here. So mine was to listen, and if there is addition, if I can have it, I'll be a very happy person so that we can do away with the criminalization of this disease. Now, lastly, it's tough for me if you prosecute on one side and even harsher penalties, and we are talking of discrimination on the other side. How would somebody disclose if those penalties are so harsh? So, it's catch-22, but I really need some more experiences as we do this. Thank you.
Thank you. I think we should take 2 more questions before we revert to the panel, and we'll start at mic number 3, please.
Thank you very much. My name's Matthew Weart. I thought these were really fantastic presentations. My one observation is to refer to, in fact, an intervention that was made by Ruth Dreyfus at the launch of the supplement to the Global Commission report, which I had the privilege of sitting on the advisory group for originally. on criminalisation. And Ruth made the point very, very powerfully and very publicly about the private ownership of pharma and about the impact, in a sense, that access to technologies, prevention, treatment, PrEP, PEP, whatever it is, where it's accessible and available, is so fundamentally determined by the economic situation of countries, and accessibility to these mechanisms, which are increasingly important in enabling people to avoid the worst excesses of criminalisation. I take into account the point Sally's made about it comes down to justice in the end. But I think Ruth made a very, very important point, which I would encourage people to go and listen to, because it was quite a big thing. She's the ex-president of Switzerland, chair of the Global Commission on Drug Policy. So could we acknowledge, I think, that criminalisation and the worst excesses of capitalism are intimately entwined, and it's not just about individual behaviour's ability to negotiate sexual relationships and about power on an individual or relational level, but everybody affected by criminalisation exists in a particular social, economic, political, legal and cultural climate which impacts on their ability to negotiate the criminal justice system and their own risk-taking behaviour. And I think it would be really good if we could emphasise that too in any of our advocacy. Thank you.
Thank you. And mic number 2.
Hi, I'm Edwin Bernard, HIV Justice Network. Sally presented on our work, although I have to say everyone has presented incredible work, and one of the things that I wanted to find out from the panel, I wanted to get a sense from the panel, we have been working very hard, many of us behind the scenes in Coalition, the HIV Justice Worldwide and others, to bring HIV criminalisation to the forefront, and at this AIDS conference it really does seem to be the case that we have more focus on this, with the expert statement being released tomorrow, this morning, HIV criminalisation on the main stage. With all that's being done, bearing in mind what Ayako was saying earlier about the unfinished business and the things that you were concerned, despite having really done an incredible job in California, what do we all need to do after we leave this bubble, and after we all pay lip service often to inclusivity and ensuring intersectionality and making sure that no one's left behind. What do is there one take-home message from each of the panelists about how we ensure that in our advocacy to end HIV criminalisation, we actually make sure that the promises that are being made here and the incredible work that's being done actually carries forward?
Thank you. Sally, let's start with you.
Okay, about the first question, I just had a couple of thoughts. I guess in talking to parliamentarians or whoever about designing legislation, the work that SALC organised for a compendium of defence case arguments to be pulled together about 6 months ago, and the intention of that was for lawyers to be able to go to a list of cases that had successfully run a defence case. When we started working on that, we were actually really surprised by the breadth of arguments that have been successful. And even though it wasn't the intention, I think it's quite a useful resource to think through when you're talking about what laws might look like, because you can kind of work backwards from that to ensure that the principles that were useful in defence are in fact enshrined in the drafting of legislation, so you don't have to run those defence arguments. The other observation I just wanted to make about that first question is there's an Australian case that I couldn't access before I came because everything's digital and I don't have that laptop anymore that had all the information on it. It's too long ago. It's about 10 years ago. There was a case where a man was prosecuted for putting his partner at risk. Well, he was prosecuted for something like intentional transmission, but in fact there was no transmission. And in those arguments, so they were, they'd both come to Australia from Africa and they were living in a relatively small community in a relatively small city in Australia. And part of the prosecution's arguments had been the devastating impact that the community's knowledge had on the woman that everyone knew that she might be infected with HIV, and she had a child, and the stigma was incredible. And when it came to sentencing, that played a really big role, how dreadful the stigma was and how it really exacerbated the harms that she had experienced. But it appeared to be absolutely irrelevant to the reason why the man may not have disclosed to her in the first place. So I think that it's important when thinking through the connections between these that we do as much work as possible, articulating that the discrimination about these cases, it impacts people before the incident that ends up in them being prosecuted. So I'll hand it on.
I'm pretty loud, so I don't think I need a microphone. I'm going to take the second one first, just because I think something that was mentioned was about context. And I appreciate the comment about private companies owning, pharma, period. The thing that I will say is that for us, the context that was most important was the fact that we needed to work with sex workers the most. And yet we were not willing as a coalition to call for the decriminalization of sex work across the board. We needed to work with sex workers, but we still live in a condition where we can't even collect information, the most basic of demographics, about who's engaging in sex work because we're busy criminalizing it. So context is incredibly important. As far as the first question for the parliamentarian, as well as the third question of what we need to do, it's one and the same. So when I first started doing outreach and education sessions, the people that were most pro-criminalization were groups of people living with HIV that I would go and speak with. I would go to support groups. And the conversation typically went like this. There was a young gentleman I spoke to. He started crying in the middle of one of these sessions, and he told me a story of how he seroconverted and how he had a boyfriend who he trusted. And there's always a story. And oftentimes they're painful stories. And so the place that we landed, and I think it's the place that I always somehow end up in these conversations, is that this is tough stuff. It's not easy. If we're having a conversation about morals and where you land, perhaps we land in different places, in different spaces. I've seen people land in different spaces and places across the board throughout this movement. But the thing that I always come back to, and the thing that I would urge you to consider, is whether you think the criminal justice system does a better job of sussing this stuff out. Do we trust the criminal justice system to do a correct job, an accurate job, the right job? And finally, is the criminal justice system the system that's supposed to be managing a public health epidemic? It's not a fit. And fundamentally, when it's not a fit, it's not meant to be. So what do? I'll tell you what I do. When I get in an Uber and people ask me what I do, I tell them. Last time I got in an Uber, it was a long ride, poor guy. He learned a lot that day, whether he wanted to or not. And he said, I'll be friends with people that are HIV positive, but I would never, ever have sex with someone. And I said, well, why? I went into a long conversation. I don't think I changed his mind that day, but I think that it's indicative of what actually needs to happen. We need to actually have those conversations with the people around us. Thanks.
Thank you for those three rich interventions, and there's a lot that could be said about each of them, but I'm going to keep it reasonably brief. With respect to the first inquiry from our Kenyan colleague, I'm delighted that you're here and you're asking these questions and want to take action on them. I would suggest that there are three particularly important references that you might want to have regard to, and I'd be happy to talk with you further about them afterward. The first is that in 2013, UNAIDS put out a very important guidance on medical, ethical, and legal considerations related to HIV criminalization. And I think it would be very useful for you and all of your parliamentarian colleagues to have a look at that. I would also have a look at the original report from the Global Commission on HIV and the Law in 2012 and the supplementary report that was just released this past weekend, both of which have, I think, very useful recommendations about, to policymakers, to states, about limiting the scope of HIV criminalization. And then, of course, the expert consensus statement on the science of HIV in the context of the criminal justice system that will be released tomorrow will be an absolutely hot off the press touchstone, I think, for your discussions with your colleagues, and I hope with civil society in Kenya, who also have a lot to contribute because they're quite knowledgeable on this issue. I loved your intervention, Matthew, about the IP policy regime, because I absolutely agree. And of course, it's no surprise that Madame Dreyfus was also a panelist on the UN Secretary General's high-level panel on access to medicines. And so that those two things would be pinging around in her mind together and the connection being clear does not surprise me. So I think we need to talk about the restrictive intellectual property, legal and policy regime, not just as a structural driver of HIV risk, because we know that treatment is prevention, as a risk of dying of AIDS, because treatment is withheld from people who are too poor to afford it, but also as a structural driver of HIV criminalization risk for that very reason, especially in an era of U equals U being front and center, which is wonderful, as an argument for limiting HIV criminalization. As the research that has been done so beautifully by Andrea and her colleagues illustrates, we simply cannot stop there because there will still be that structural driver for some of the most marginalized. In terms of what's next, Edwin, I can't give you one take-home message, but I will give you 3 or 4, and these are just reflections for all of us. The first is, and I would be remiss if I didn't say this, what you should do if you haven't already is go and look at the HIV Justice Worldwide website, and you should poke around on there on all the useful information and resources, and you should get your organization or you as an individual to join HIV Justice Worldwide, hivjusticeworldwide.org. So that's one very concrete thing to do, and share it with your coworkers, your friends, your family. Share it through your social media channels and so on. Point people to that really useful resource. Do the same thing, of course, with the expert scientific consensus statement that is going to come out tomorrow. There will be related materials because it's a dense document, as you might expect. It's written by scientists. It's in a peer-reviewed scientific journal. It goes through the science in excruciating detail, which it absolutely needs to do. There will be plain language materials coming forward, including from civil society advocates like those involved in HIV Justice Worldwide, to try to translate that and make it a little more accessible for advocates and for policymakers and so on. So share those materials, and that will be, I think, quite useful. In terms of where we go as advocates, beyond just doing, spreading the information around, I think there are a couple of things that we need to grapple with, and you've just touched on it as well. The need for understanding how HIV criminalization operates differently depending on where you're situated socially, economically, politically. And that actually, I'm pleased to say, although I don't want to suggest it's perfect, is something that we've been really consciously trying to do in mobilizing and building community and community consensus about limiting HIV criminalization for a number of years in Canada. And in part because the law of sexual assault is the thing that has been used to prosecute people. It has been really important for both reasons that are principled and also strategic to engage with feminist legal academics, with women working against violence against women, because in some cases those have been voices that have argued for an expansive application of HIV criminalization in the name of protecting women. And the impulse is understandable and laudable, but not always fully thought through. And we've had very useful and interesting discussions, I think, over the years to build, at least in our context, feminist critiques of HIV criminalization and how it works to the detriment of women, including particularly women living with HIV and some of the most marginalized women living with HIV. And that is really important to do for reasons principled and strategic. And in those discussions and elsewhere, there has been a conscious effort by HIV criminalization activists or anti-criminalization activists in Canada to make the links with criminalization of sex workers. And so there is a national coalition that is working for sex work law reform that we're part of. And in those discussions, HIV criminalization as it affects sex workers who are living with HIV is front and center. I would also say that the coalition that we formed nationally certainly includes a strong support for the decriminalization of sex work, so the coalition that we formed around HIV criminalization. But it is also a coalition that has tried to take seriously, not always perfectly, but has tried to take seriously the disproportionate impact of HIV criminalization in gendered ways, but in particular also on Indigenous people in Canada who are disproportionately represented amongst the women who have been prosecuted, and on Black people, particularly amongst the men, the disproportionate representation of Black men among those prosecuted. And those issues have been recurringly part of our advocacy on HIV criminalization, although I'm sure there is more that could be done on that. And then the last thing that I would say is we need to grapple with the question of consent. And maybe this is something that we've been particularly grappling with because it's the law of sexual assault that is being used in Canada. But it is, I think, really at the nub of the reluctance to engage fully with the notion that we should be vacating the criminal law from this space. And I understand why. Because people sometimes are not nice to each other, they don't act in the most ethical ways in sexual relationships, and there's definitely a gender overlay here, especially pronounced when we're using the law of sexual assault. And we need to have good, solid arguments in response to the person who quite understandably says, but shouldn't I have the right to know? How am I giving informed consent to sex if I don't know this thing about my partner? It's the question that sort of hangs over all of this. And I think in some cases we've come up with some good answers for it. And there are good reasons why we should be limiting the law here, including law of sexual assault. But I'm not sure that we've quite fully articulated in a way that is as compelling as it should be how to deal with that sort of nagging, lingering concern that people have. And that, I think, is perhaps psychologically our biggest stumbling block in getting to our law and our policy to a more sensible place and a more science-based place and a more public health friendly and human rights friendly place. So I look forward to people's ideas about that.
Thank you, Richard. And just to briefly follow on that, I think that was, I think how we can move forward there as well is to really emphasize that shared responsibility for sexual interaction, so that it doesn't fall on a person living with HIV, but that is very much shared between two sexual partners. I just also want to just state too that, and that really builds also on a meeting we had yesterday at, discussions at the Beyond the Blame conference yesterday. I think it is really important for next steps to think about what is the role of the state in interfering with consensual sexual relations. So I think, and within that, there's really an opportunity to work together with the movement to decriminalize sex work, the HIV decriminalization movement, same-sex, all of these aspects of sexuality that have been criminalized, to really push back and really stand together on that front. I think that will be really important, and I have a lot of hope for that. Thank you.
I didn't want to talk too much at first. I just wanted to respond to Edwin's question. I think I agree that one of the issues that we really should be working on more is clarifying around disclosure. So we're so used to using the term disclosure and framing it in our, public healthy type ways. But if you talk to someone outside this little circle, they really don't get it. They do think that people should tell a potential sexual partner that they have HIV. And so I think that what I would like to see is some more work done discussing that in a different way. So some work about how difficult it is to tell potential sexual partners a whole range of things, whether that's someone that you want to have sex with and then go off and do whatever else, you're shopping or something, never see them again, or whether it's because of, it's romantic and you're thinking this could possibly be someone I spend time with. And I think there are a lot of comparisons of the difficulty of telling someone that you have some other type of illness or disease, that you have cancer. Perhaps you're in your mission, whatever all those stories are, that you have kids with someone from another relationship, that you've been trying to struggle with your gambling problem. Many things are very, very difficult for people to disclose to people they don't know well and haven't known for a really long time. So I'd like to see us think how we can start to describe that to people, that they will empathise with it more and understand more the difficulty people face disclosing that they have HIV. It's not that, it's disclosing that you have something that people will go off and use that information about you however they wish, to your detriment often. Yeah.
Can I add just one concrete action? It's going to be really short. The Human Rights Networking Zone in the Global Village, booth 520. You can go and take your selfie with a photo frame with a message about unjust HIV criminal prosecutions, post it on your social media feed, and raise the profile of this issue, which of course is getting more profile at this conference than it has before. So that's one very concrete thing you can do before you leave this bubble.
Much. I think, thank you to our wonderful panelists. You've been amazing, and showing us that partnerships between legal experts and communities really has benefits for making an enabling environment for communities of people living with HIV, and asking all of us to keep doing what we are doing to raise this issue and to make sure that we are dealing with the structural barriers that sometimes, affect how communities come forth for treatment or prevention interventions. Thank you to our panelists. Thank you to everyone who sat through the presentations. And thank you to my co-facilitator. And see you soon. Thanks.